Welcome to the Napa Legal Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director.
And I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we'll be covering the settlement of a case where California law previously excluded religious schools from receiving funding under the federal Individuals with Disabilities Education Act. Then we'll cover a Florida court case involving a parental right to notification and consent before a minor child can have an abortion. And we'll conclude with the U.S. Supreme Court's admittedly disappointing ruling in the St. Isidore case.
Thanks, Frank. So, continuing our theme of religious freedom and education, California has a program through the Federal Individuals with Disabilities Education Act that allows children with special needs to receive the funding that's necessary in order to participate in special education initiatives at no cost to the children's parents. So, as you can imagine, this is a great blessing to children with special needs and their whole families to have top shelf educational opportunities. And so, recognizing that some of the best educational opportunities for children with special needs are not in the public school system, but actually in special private schools that focus on a variety of special needs and really learn to do that well. Um, and so, this funding is available in these private schools. But you guessed it, the funds can be used at a range of private schools unless the schools are religious. This may sound like the same song, different verse, and it very much is. So, as a result of this California policy, parents of Jewish children with special needs were finding that they couldn't put their children in schools that furthered their faith and also address the children's special needs. And so they were stuck in this either or situation. You either find the educational environment that helps with the special needs or find the educational environment that helps form the child's heart, mind, and soul in the family's tradition. So, represented by the Beckett Fund, this program was challenged, and fortunately, there was a judgment from the Ninth Circuit that encouraged the state to discontinue its policy excluding religious private schools from this program. So, I want to use the exact wording the court provided. I think it's really helpful. The court hereby declares that the requirement that an entity be non-sectarian in order to apply for, obtain, and maintain certification as a non-public non-sectarian school or a non-public non-sectarian agency, and to contract with public educational agencies to serve violates rights protected by the Free Exercise Clause of the First Amendment of the United States Constitution and is facially unconstitutional. So, for non-lawyers, facially unconstitutional is quite a condemnation. It means, as it is written, I don't even. The court's basically saying we don't even need to hear the specifics. This law, on its face, violates the First Amendment, the Free Exercise Clause. So it's an encouraging victory for educational freedom and religious freedom, and continuing that movement. I want to note a couple things that I think were special about this case, not only on its own, but kind of as a data point in this overall trend of religious freedom. So Beckett, who represented the families here, in addition to their efforts in court, they actually conducted a survey of both Californians specifically and Americans generally to see whether including the Jewish students in the program would have popular support. The overwhelming answer was yes. And I think that that's a really important part of the story here because sometimes the mainstream media portrays these victories as benefiting an interest group, or sort of almost simple, like, oh, they won on a technicality, but this wasn't a real victory, or no one really wants this, or, this group is just good at litigating. But I think it's really important to show that that's actually not the case at all. This isn't something that benefits an interest group. This furthers what the consensus is, the common good. So you can see the whole story here that this is what people want. This is what would win at the ballot box. And this is what's winning in court. It's not just this sort of anomaly that's winning at court, but doesn't reflect popular opinion. So I was very encouraged by that, and I really appreciated Beckett's initiative in recognizing that the court victories matter, but the cultural story also is really important. And so they really, I think, had a great strategy to represent the children and tell their story in this case. I also wanted to mention that as you hear this fact pattern, these children of Jewish faith with special needs weren't able to receive the same educational opportunities or had to make the decision in these trademarks, um, or sorry, these trade-offs, that like, oh, this keeps happening. Trinity Lutheran, Carson, what didn't those cases settle this? Like, haven't we already answered this question? Well, yes, the law has answered this question, but proactive measures are still needed. So just because a legal victory is on the books does not mean that everything falls into place. It's actually necessary to do the work to bring these legal victories to fruition. So again, just because a lawsuit was finished does not mean that similarly situated parties have those same benefits unless some kind of action is taken. And so I think it really underscores the usefulness and the critical role of efforts in other branches of government, like the executive branch or the legislative branch, to take these proactive steps. So we have recently the White House Religious Liberty Commission doing this nationwide audit. Where are we behind on religious freedom protections? Where are our practices running behind the law? Where are we violating the Constitution in a way that we've already clarified is unacceptable? And then again, state initiative like what Governor Stitt is doing in Oklahoma, the legal protections may be there, but those protections don't implement themselves. They stay on the books. And so taking that proactive step to do this religious liberty audit of Oklahoma and see, where are we still living in, the 1880s, no sectarian kind of religious bigotry world. So I think it's really important to see those non-legal efforts complementing the legal victories, because otherwise it's just going to be this step by step, victory by victory, case by case, manual labor, basically. And so this case is an important victory. I think it also highlights how important it is to implement legal victories so that not every situation requires a litigation endeavor, multi-year litigation endeavor. So, Frank, we've talked a lot about both educational freedom, parental rights, religious freedom on the podcast. What are your thoughts on this case in California, and how do you think this impacts the policy and legal landscape overall?
Yeah, a couple of things. First of all, like you said, hats off to Beckett for their work on this and on a lot of levels. I mean, I think, again, like you said, good facts are really important, that the right cases go up to make good precedent, right? So I think this one, I'm going to try to refrain from talking about St. Isidore because it's still, as of recording time that just came out yesterday, it still hurts a little bit. But also we're going to talk about that at the end. But that's a little bit more of a bold optical choice, right? It's like, oh, this is a Catholic school that's going online and then is going to apply for charter school status. Like it just looks like a bold, like, okay, religious organization going for public funding, all right. Versus like Carson v. Macon, right? It was, oh, if you live in a rural area, you can't even reach a public school. So there's this program for you to get assistance to use, a school close by. If that's a religious school, who cares, right? The optics are pretty good. So to this point, the optics are great here, right? And I don't mean to be like Machiavellian about it, but it is an important thing when choosing cases, right? This is, Jewish families who have disabled children who want to make sure that they're going to the best schools that accommodate their special needs. I mean, really important that you're getting sympathetic cases. And like you noted, the survey that Beckett put out about to Californians and to Americans shows overwhelming support. The facts matter, and so I think it's just Beckett in general, I think, does a really good job of choosing good, sympathetic, solid cases, and this is really important. And to your point, it's important because this fight for religious liberty is like a chess match, right? It's really dangerous to think like, oh, checkmate, like, oh, we won this case at the Supreme Court, or oh, we got an agency to back down. Not how it works. There's a series of steps. There seems to be a playbook from opponents of religious liberty, right? Where first you exclude all of the religious organizations and say, well, it violates the Establishment Clause if we give them any money for any reason. And then when you have cases like Trinity Lutheran start to come through, it starts to change the scene a little bit, but they keep going. And so you get laws like what was in Carson v. Macon in Maine, and you keep religious organizations out of certain publicly funded programs, and you say Establishment Clause, and then when you lose that one, you know, they keep at it. Like the opponents of our of the religious liberty movement keep at it, and we see that because St. Isidore, right? Even though Carson v. Macon, I thought was pretty clear precedent on publicly, excluding religious orgs from publicly available funding. Clearly, it's not that cut and dry, so they keep fighting. And then we've also seen movements where, okay, if you can't exclude organizations from public funding for being religious, let's just switch it up and exclude them for not welcoming all employees and comers who identify as LGBT, right? So you switch the criterion a little bit. Anyway, I don't mean to go on and on here, but I think it's important to your point. Like, it's a long game fight, and the side who is pushing against religious liberty seems to have many steps and many resources. So it's really important, like you said, for one, that we keep picking the right cases and pushing back and not take these infringements on religious liberty lying down. And then also, to your point, to make sure that we're using the proper channels in all branches of government, that we're not just relying on lawsuits. I mean, yeah, I mean, I should just leave your examples, what Governor Stitt's done in Oklahoma, what President Trump has done with this Religious Liberty Commission. Really important work, that this be an all-encompassing effort, right? There's no one kill shot that's going to give us the exact religious liberty precedent that we need to make sure that people of faith can just be what they're supposed to be in the public square. So the fight goes on.
I want to underscore something you just said, Frank, something that I've really learned from you in our conversations on this, which is um, that as well the legal efforts are done well. Lawyers are trained to undertake these efforts, but these issues are questions of flourishing for all of society. And so courtroom victories they're part of that. They're part of the recipe, but they're not an outcome of themselves. The outcome that's being pursued is flourishing, is children firmly grounded, strong mental health, the resources they need to excel intellectually, the environment they need to grow as people. And so the outcome that's being sought is that flourishing. And so um, the litigation is an important means to that end, but it's not the end of itself. And so I think just kind of widening our aperture as we look at cases like this, and I think Beckett does a tremendous job of telling that story. The victory is exciting. It's important. It's wonderful. The outcome is actually not the legal victory. The outcome is actually a society in which people are able to flourish because of religious freedom for everyone everywhere. And yeah, I think this case is such a great indication of that, and the way they've told the story, not just in the courtroom, but also by looking at kind of what society sees as good as well.
Yeah. No, that's a great point. And I don't want to belabor this, but exactly to your point, especially in the legal movement, we tend to get really bogged down in like getting the law right or getting the procedure right. And that's important, right? But it's not, it's easy to, exactly what you said, to make the means into the end kind of without realizing it. Like, I remember somebody commented after Dobbs came out, right? That, people were not clamoring for change for 50 years because they were so outraged by the judicial activism that would create a right that's clearly not enumerated in the Constitution to abortion. It's like, no, people came out because they thought abortion was wrong and that it shouldn't be enshrined by law, right? So I think it's important that as we fight these legal fights that are often quite technical, that, yeah, exactly what you said, that we not lose sight of the big picture of what we're doing. So with that, we will pivot from California to Florida, as many people have done in recent years. And this is a really interesting legal case. I don't want to spend too much time in the weeds, but I think the weeds are a little bit important here. So basically, Florida law, like a lot of laws, state laws, has a requirement that if a minor child is seeking an abortion, that the parents have the right to be notified and to give or withhold consent. And then there's also, again, like in a lot of states, there's a judicial waiver provision where, a minor child can go before a court and give testimony and explain why the parental notification and consent rights should be waived. And I think usually it tends to do with like extremely disordered or abusive situations, right? Where like a child can go and say, listen, my parents are, they're beating me or whatever. They're not going to consent to that's so the judicial waiver thing, it's pretty common. But this is really getting to the heart of a constitutional issue surrounding the judicial waiver issue. So in this case, 17-year-old girl goes to the trial court, asks for judicial waiver to procure an abortion. The court says no, and the court says no because basically her testimony is not credible. She didn't meet the standard, so she loses. It's appealed to the Florida Intermediate Appellate Court, and the appellate court does something really interesting here. So for one, they affirm what the trial court said. She's not entitled to it on the fact. But then also the Florida Court of Appeals certifies the question by its own motion, even though it wasn't raised by the parties, to the Florida Supreme Court asking whether the judicial waiver of parental notification and consent violates due process under the 14th Amendment. So really interesting posture. And I have just a few things to say here. So first of all, we have an argument that's becoming familiar, right? This tension supposedly between the parents' rights to notice and consent to decisions regarding their children in tension with a minor's supposed right, in this case, to an abortion. We've seen something similar with parental rights regarding like secret transitioning in schools, right? Well, the parents have rights to notice and consent, but the children supposedly have these rights to autonomy or what have you. And it's problematic in the first instance anytime you're creating this supposed tension because minors don't really have rights in the same way that adults do, right? Their rights, they have them, but they're kind of kept in custody by the parents, right? The parents kind of hold those rights on their behalf, at least a lot of the time. But the other thing too, the court makes its opinion on these supposed tensions very clear. And I want to read from a couple things. So first of all, the court quotes from Troxel v. Granville and says, yes, parents do have fundamental rights, right? And perhaps the oldest of the fundamental liberty interests that the 14th Amendment secures is the right of parents to the care, custody, and control of their children, right? So the Florida court is saying, listen, there's a constitutional traditional case that parents have control over their children, right? The minor child responds that she has constitutional rights here to an abortion, which the court says we're not persuaded. Whatever asserted constitutional abortion rights may have justified Florida's judicial waiver regime in the past, unequivocally have been repudiated both by the U.S. Supreme Court and the Florida Supreme Court. And obviously on the federal Supreme Court, Florida's talking about Dobbs, so there's no longer any talk of a constitutional right to abortion. And then they cite a Florida Supreme Court case as well. So I think it's interesting, right? The court concludes that in Florida, if there was previously a tension between child's right to an abortion, parents' right to care and custody over their kid, it's no longer a persuasive argument. So the Florida appellate court here concludes this section by saying, therefore, any deprivation of parents' due process rights to notice and an opportunity to be heard can no longer be justified by their children's asserted constitutional right to obtain an abortion, much less a secret abortion that cuts presumptively fit parents out of the decision. So shots fired. They're making it very clear where this appellate court stands on this. But one thing I want to note on the procedural question here is that, and this is not just academic semantics, I think it matters. As I was doing the research for this, a lot of media outlets were reporting that the Florida Court of Appeals declared the judicial waiver provision in Florida unconstitutional. The court makes clear that it thinks the law is unconstitutional, but I don't think it actually declares that. If you read the court's articulation of its decision, they say, after a hearing at which minor testified, the circuit court found her testimony inconsistent, not credible, and it determined that she failed to establish entitlement to a judicial waiver. We affirm, and we certify a question of great public importance to the Florida Supreme Court. So what the Court of Appeals, if I read it correctly, is affirming is the ruling against the minor child on the facts, right? Her testimony was inconsistent, not credible, and so she doesn't get the judicial waiver. That's what's being affirmed. But then further, the court is certifying a question on its own volition, which is really interesting, to the Florida Supreme Court. I was actually talking to a colleague yesterday, explaining to him what was going on here because he was very confused. Like, well, it doesn't seem that there's a case or controversy that has to be settled by the constitutional question. I said, well, yeah, well, and that's a problem at the federal level, but this is state court, so let's look at it. And again, I'm not a Florida lawyer, so I'm not an expert on this, but I did a little research. I read an article in the Florida Bar Journal, I believe. And there's a mechanism in the Florida Constitution and based in the rules of appellate procedure where a question can be certified to the Supreme Court by the appellate court. And the article says that the High Court may review any decision of a district court of appeal that passes upon a question of great public importance. So it seems like there's this great public importance question whereby the Supreme Court can weigh in on an issue that was passed on, even a constitutional question here, by the intermediate court. So I think it's really interesting. And again, taking the legal nerd part out of it, I think it's a really important question because, again, if my memory serves, this is not an unusual thing, having this judicial waiver of parental notice and consent requirements. But now that Dobbs is has ended Roe and Roe and Casey are no longer the law of the land, I think that might change the analysis. I think that was always the justification, right? You can have a judicial waiver for like a 16, 17-year-old because, again, it comes down to balancing parents' rights versus child's rights. But there is no more federal constitutional right to an abortion. But there is still a parental right, especially when you look at cases like Troxel. So I think it's an interesting question. And so I do wonder, for one, whether we'll see other states follow suit and say, yeah, judicial waiver doesn't fly anymore under the 14th Amendment, or two, whether the US Supreme Court may one day take this up and weigh in whether these judicial waiver issues pass muster under the 14th Amendment. So, Mary Margaret, I know that was a lot. I'd love to hear what you think here.
You summarized that so beautifully, Frank, and I think you told a really important story, which is how is the emphasis on parental rights, which have always been important, but I think are particularly relevant, as you said, post Dobbs, and as we're seeing some of the child sex change efforts in schools and kind of medical procedures. So I think it's first of all, we talk a lot about the role of states here, kind of structurally how the states are meant to work with the federal government to further the common good. I think it's encouraging to see this going through state court in Florida, and I think that's really important. I want to say one specific note on this case, and then zoom out a little bit and look at kind of the parental rights trends that we're seeing overall. So the first point was just I really appreciated from a policy standpoint the clear-sightedness of the court here, and I think you as someone who's worked in like the family court context have an appreciation for their clear-sightedness. They don't need to stand on ceremony. The questions are the best interest of the child, and so there's a common sense kind of groundedness in reality that you see in these family court decisions, and they're just saying these parents are presumptively fit. So they have there's no basis on which to exclude them from decisions about their child unless there's some sort of demonstration that these parents are not fit, are engaging in some kind of uh, behavior that shows that they're not acting in the best interest of this child. But in the absence of that, we have no role to play here. And I thought that was very well put. I also thought that their evaluation of the young person's kind of where that person was psychologically and whether their testimony was consistent. Another example of clear-sightedness. So simply looking at the realities, because I know in the family court context, every question is a fact specific question in a sense. So I thought that was great, and I think insightful for other parental rights sort of cases, maybe in the transgenders, child sex change context, just recognizing, putting aside morality, putting aside first principles, simply looking at, as they say these days, following the science, psychological development in the prefrontal cortex does not occur until, much later. And so being realistic about the important role that presumptively fit parents have is the least we can do, and something that I think should be violently bipartisan, completely bipartisan. I mean, nobody should be disagreeing about that. And so that was encouraging. And then I just zooming out a little bit, we've looked at parental rights in the Mahmoud case. We've looked at parental rights in some of the child sex change cases in schools. And I think one of the challenges that come up with parental rights, particularly when they're framed in the constitutional context, I've heard, it's natural to look at a rights issue and then look to the U.S. Constitution. I think that's a healthy instinct. It's a normal instinct. And then that ends up in free exercise world. But I know I've heard lately, people saying, well, what about parents who aren't in free exercise world? This isn't an exercise of religion. It's simply a decision they're trying to make in the best interest of their child. What recourse do they have? Because there's a little bit, I think ambiguity might be the right word, or at least like clarifications needed on what federal remedies are available for them, for those parents, especially if they're not, invoking religious protections. Um, so I certainly think the rights are there, as they mentioned in, Troxel versus Granville, but it's just a little bit harder to, a little bit rusty, I guess, or clunky, I guess maybe is the way of putting it. However, at the same time, structurally, states were given general police power. They're not limited to the way that the federal government is to the enumerated powers. They're supposed to have a lot of work to do with respect to the welfare of their citizens. And so I think we saw this done really well in the homeschooling movement. There was reference to the US Constitution consistently, absolutely. But there was just a lot of effort and work and work done at the state level to ingrain these rights in an unmistakable way through the law. And so I'm encouraged to see Florida doing this. We talked recently about I think it was the Indiana Parental Bill of Rights. So just seeing that, we use the word proactive a lot, seeing that proactive approach where we're saying, hey, we're not going to leave this up to chance. We're not going to, we're not going to leave this in sort of a murky waters. The states are going to do what's needed to do to clarify that their children are protected by this analysis. And so, in fact, I would actually love to see legislation in this area too. So, not only the Florida Supreme Court speaking to this, but maybe even some legislative action clarifying the role of parents and in their primacy, as long as in the absence of some kind of showing that they're unfit, the primacy they have in building the best interests of their children. And we will close then now, continuing the theme of not exactly parental rights, but religious freedom, and certainly in the formation of children, by discussing yesterday's news that in a landmark 4-4 decision, as the courts put it, equally divided, the Supreme Court upheld the Oklahoma Supreme Court's decision to prevent the funding of the St. Isidore of Seville as an Oklahoma virtual charter school. So what's going on here? The court issued an unsigned 2-sentence opinion that simply states that basically it was a tie, and when it's a tie, the lower court's ruling is upheld. And so St. Isidore's virtual school, remains ineligible for state funding. The first question is, okay, that's disappointing. Is this a setback for religious freedom and education? And as I was reflecting on that, I realized, well, there are 2 questions there. The first is this a practical setback? The second question is this a legal or policy setback? I would say it's definitely a practical setback, absolutely. But I don't think this is a long-term setback simply because the opinion was not substantive. And so the law hasn't changed. So I would say, like, almost, you used the analogy earlier of the chessboard. I mean, there's been, in a way, no move, which is, it's time consuming, but the law hasn't changed here. And in the interpretation of the law hasn't changed here. And certainly, in a sense, there's been progress because there's been more public attention on these issues. But certainly there's no getting around the fact that, at least in the short term, this was disappointment. So Frank, you, as we often note, you've been following the St. Isidore case and this questions generally, but before they were cool. And so I'm sure yesterday was a blow for you. But let me know, like, what were your initial reactions, and then where have you landed on what this case means?
Yeah, those are great questions. So initial reaction was, I wasn't shocked. I was a little surprised. I thought it would be 5-3, and that we would get a like a positive outcome. So the first reaction, honestly, was frustration because I would think that internally within the court, if they knew that they were split, that they wouldn't have taken this because it generated a huge amount of discussion and litigation and conversation in the public square and all of this. And so my assumption was that, for one, they knew that Justice Barrett was going to recuse herself before cert was granted, right? So this wasn't like a surprise that, oh, we thought we were going to have that vote when we took this case. They already knew they wouldn't have her vote. And then also the fact that I discussed this with Chris Shandovel on our podcast special episode last week, and I still encourage everyone to listen to that because the First Amendment and the public school history questions are still very relevant. But I think I was also a little surprised because Chris had mentioned that you need the Chief Justice, right? Obviously, if you're going to get 5 out of 8 votes. And the Chief Justice wrote Carson v. Macon, and he also wrote Fulton versus Philadelphia, which deals with the whole, well, right, religious organizations can be involved in public funding, licensing kind of programs. In that case, it was the foster adoption agency. So I was a little surprised. I also get personally very frustrated by unsigned opinions, not just out of curiosity, but because I want to know, right? Like if the Chief Justice thought that Carson was far enough, but St. Isidore was a bridge too far, I'd kind of like to know that. If somebody else was the one who didn't join on, because we know 3 of the 4 no votes, good guess. But I'd like to know the reasoning, right? Because to your point, it's like it's not a legal setback, it's just kind of nothing, right? You get this one sentence, split court, Oklahoma's decision stands. Like, well, I don't know what to do with that. So I think two things that I'll end with here. For one, I agree with you, and I hadn't thought of this, so thank you for the little note of hope here that, the victory of just the public discussion. You're right. This case has shifted the Overton window in that like 5 years ago of talking about like starting an explicitly Catholic school and funding it via charter school dollars was like no way. That's not even in the mainstream conversation. But now it is. Like now this is a real thing that a lot of people within the religious liberty movement and the country more generally are discussing as an option. So that's a win. And then the other thing I would say too, to get into like court politics a little bit, is you clearly have 4 votes without Justice Barrett, right? Which means presumably you have 4 justices, not including Barrett, who are interested in getting this decision right. Um, we don't know why Justice Barrett recused herself, but I would not be surprised if we see another attempt in a different state to start a religious charter school, apply for charter school funding without the help of the Notre Dame Law School or religious liberty clinic. Because I think if there's a way that you can do this where Justice Barrett does not have to recuse herself, I wouldn't be surprised, honestly, if you see cert granted and another redo on this case. So remains to be seen. This is all just conjecture, but I don't think this is over. And I agree with you that there's some helpful discussion, and these issues remain really important to kind of fix the proper boundaries of free exercise and establishment clause, how they play together, and what the proper role is of religious schools in publicly funded programs. So to be continued.
Yeah, it's interesting what you said, Frank, about just the unsigned opinion. I didn't get a chance to look this up, but I was kind of curious how common that is. I don't I know that there are what is it, the shadow docket, where an opinion will come out without like oral arguments taking place. But this was the first time that I had been following a case closely, seen oral arguments, seen all the briefings, and then had the whole thing conclude with a 2 sentence unsigned opinion. I don't recall ever seeing that. Do you know, like, does that happen?
I don't know, because I'm thinking back to law school when I would just, we'd have to read SCOTUS case after SCOTUS case. And from memory, the only like unsigned per curiam cases that I can remember are unanimous ones, where obviously there's no need for a signature because everybody voted one way. I can't remember seeing a split court where you don't see who split which way. I can't imagine this is the first time in history, but I can't remember any other instance of it. Well, not a high note maybe to end on, but needed to cover that case. So, um, with that, I think we'll leave it for next week. So, thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we would appreciate it if you like this podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations.
Thanks so much, Frank, and thanks to all of you for listening. We'd also like to send a special thank you to our content and program manager at Napa Legal, Joseph Clement, for all his work preparing these weekly episodes. He does an outstanding job, and it's an absolute privilege to work with him. I know we both learn a lot from working with him, Frank. So thanks a lot, Joseph, and we will talk to you all next week. Thanks for joining, and God bless.